Hi, I'm Michael Osrin, an associate at Nicholes Family Lawyers. Welcome back to our YouTube channel, where we unpack complex family law issues in a clear and practical way. Today we're talking about child protection in Victoria, what it means, when the system gets involved, and what families need to know if they find themselves navigating it. Child protection is a specific government branch that operates within the Department of Families, Fairness and Housing, previously referred to as the Department of Human Services. Its main function is to safeguard children from abuse, neglect, harm, and where their families are unable to protect them. Child protection is governed by the Children, Youth and Families Act 2005 and fulfills the following essential roles. It investigates matters where it is alleged that a child is at risk of harm, refers children and families to services that assist with maintaining their ongoing welfare, applies to the Children's Court for orders to be made if the child's safety cannot be ensured within the family unit, and administers the protection orders granted by the Children's Court. A child is considered in need of protection if they are at risk of experiencing physical, sexual, emotional, or psychological abuse, or neglect that could affect their development or health. Importantly, this extends to the likelihood of harm, not just the harm that has already occurred. So how does child protection get involved? Child protection can become involved after a report is made, either by a member of the public or by a professional relating to concerns for a child. Some professionals, including doctors, teachers, psychologists, and police officers, are mandatory reporters. This means that they are legally required to report a reasonable belief that a child has suffered or is at risk of suffering physical or sexual abuse. Once a report is made, the department may engage voluntarily with the family to address concerns or, where the risks are more serious, intervene more formally. In cases involving imminent risk of significant harm, a child can be removed immediately, with a court hearing required within 24 hours. This is referred to as an application by emergency care. Where child protection concerns escalate, matters are heard in the Children's Court rather than the Family Court. Like the Family Court, the decisions of the Children's Court are guided by the best interests of the child, although the framework for determining that is slightly different. Under Section 162 of the Children, Youth and Families Act, the court looks at the likelihood of physical injury, sexual abuse, emotional harm, or developmental harm to the child. A child will only be removed from a parent where there is an unacceptable risk of harm, and any finding of likely harm must be established on the balance of probabilities. So how does this interact with family law? Family law matters, including matters such as residence and parenting arrangements, are usually dealt with in the Federal Circuit and Family Court of Australia. But when child protection concerns are raised, the jurisdiction of the Children's Court can be invoked. Under the Family Law Act, a court cannot make a parenting order in relation to a child who is already under a state child welfare order until such time as the department withdraws involvement and any protection order made in the Children's Court ceases to operate. This means that even where parenting proceedings are on foot in the Family Court, they will be put on hold once an order is made in the Children's Court. It is crucial to understand where and how the Children's Court and Family Court intersect to ensure that your matter is being determined in the correct jurisdiction. So what should you do if you're involved in a child protection matter? If you're a parent or carer facing an allegation or investigation, we recommend the following: seeking legal advice immediately, keeping a diary of all dates, conversations, and actions taken by the department, keeping copies of everything provided to you in writing, preparing a chronology of significant events for your lawyer, and accessing support for yourself and your child throughout the process. Our firm has significant experience assisting carers, either kinship, foster, or permanent carers, to navigate the child protection system. Although the voice of carers is not as respected as it should be in children's court proceedings, there are options available for carers to have more involvement in decisions made. Where the department makes decisions about a child in out-of-home care, they are required to consult the child's carer. Additionally, carers may seek to be joined as parties to proceedings if they can show that they have a direct interest in the proceedings, and it is reasonably practical for them to be joined. This second limb of reasonable practicability means that to be joined as parties, carers must demonstrate a unique position that is not being pressed by the department or a parent. Child protection matters are extremely sensitive and require an in-depth understanding of the relevant legislation and procedures employed by the department. Whether you are a parent, carer, or family member concerned about a child's safety or facing allegations, getting the right legal advice from the start can make all the difference. If you would like to talk through your situation, please contact Nicholes Family Lawyers on 03 9670 4122 to arrange a consultation. Thank you.